GIL recently organized a mock interview session where the students practiced through one-on-one interaction session with known legal experts. They received valuable feedback about the various aspects of their overall performance to enhance the chances of their success in the real interview.
What do you understand by relevancy of evidence?
Sir, relevancy draws an inference about the fact and issue and the relevant fact. It is the inference of the truth. Relevancy is defined under section 6 to 55 of the Evidence Act. All relevant acts are not admissible in nature.
Anything recent happening in the surrounding of our country?
Sir, many incidents have taken place in the recent past. One of them is the Bangladesh incident. The other one is very major, that is Hamas and Russia. They had been fighting.
Can you tell anything about section 3 of the Evidence Act?
So section 3 of the Evidence Act deals with the interpretation clause. There are some definitions which are given underneath it.
If two judgments are cited before you, which are contradictory, which judgment you would prefer?
Sir, I will
On
look
the
upon,
same subject, two judgments are given to you.
sir, I will look upon two things first. Firstly, the court which has given the judgment. If it is for High Court or the Supreme Court, then I will prefer the judgment of the Supreme Court, sir. And then the formation of the judges. Like the bench consists of how many judges, sir?
If there are two judgments which are conflicting on the same subject, which one do you apply? District court, etc. are not binding. Only High Court, only constitutional courts, Supreme Court and High Court. We will talking of that.
Yes, sir. Sir, if there are the two judgments of the one is of the High Court and one is of the Honorable Supreme Court, sir, in that case, sir, the judgment of the Supreme Court will prevail, as Article 141 provides that the law declared by the Supreme Court is the law of the land.
Do you know about Section 125 of this CRPC?
Yes, sir.
What is that?
So Section 125 provides for maintenance to the certain specified category of persons who are unable to maintain themselves.
Procedure for trial of warrant cases.
Yes, sir. Sir, so the foremost step is that, so the magistrate will check the compliance of Section 207 and 208 of the CRPC, which provides that whether the documents are supplied to the accused or not. So thereafter, the magistrate, on the basis of the material brought on the record, will decide whether there is a case made out. Then either he will frame the charge or he will discharge the person. So then if there are sufficient material on record, sir, in that case he will go on framing the charges. And sir, after framing the charges, so there will be prosecution evidences. Thereafter there will be defense evidences, and sir, there will be judgment accordingly, sir.
If something material has not been put to the accused in 313 CRPC, statement number 313, can the accused take the benefit of that?
Sir, in that case, it will not be considered by the court in deciding the case, sir, as per a recent judgment of the Honorable Supreme Court, sir.
When a person is only suspect, not an accused, whether he can seek bail from the police?
Sir, bail is undertaking given by the accused persons for compliance with the ultimate orders of the court, undertaking that he will comply with the ultimate conditions that is imposed upon him. Sir, if a person can apply for bail if he is arrested, and a person is arrested if there is a suspicion about him that he has committed a cognizable cases or not, sir.
In what circumstance magistrate can grant bail in 302 case?
Sir, as per Section 437 of the CRPC, sir, any non-bailable cases the court has the discretion to grant bail. Sir, by considering some material brought on record, so the magistrate can grant bail. So these can be the nature and gravity of the offences, sir, previous antecedents, sir, other bail considerations can be taken into account.
What is the relevance? Can the hearsay evidence be read as a authentic evidence with regard to admissibility? Otherwise, basic law is hearsay evidence cannot be read into.
So there are certain exceptions to the admissibility of exclusion of hearsay evidences. Sir, one of the situation can be, sir, as a dying declaration. Sir, other exception can be, sir, if the fact is part of the same transaction, then by virtue of section 6 of the Indian Evidence Act, that fact can be used as a evidence.
And this is proved on record that this has happened, so that will be. Any important person who is in controversy staying in India?
So the former Prime Minister of the Bangladesh,
What is
Mrs.
her name?
Sheikh Hasina, she is staying in India. Despite that, her government was toppled, and there was an interim government that has been set up in the Bangladesh.
Is still she staying in India or she left India?
Sir, as of now, sir, she is still staying in India.
The session helped the students gain a better understanding of the interview process and their own preparation level.